Please be seated. Good morning. No pressure on the lawyers. Nice audience today, but not putting any pressure on you. I want to begin by thanking Montana State University for the opportunity to have this argument on campus. We appreciate coming to the campus, and it's nice that we appear to have a lot of students that are in attendance. So welcome. Thank you for being here. I want to also thank Dean Gagliardi and the U of M Law School for the introduction. It's always helpful to try to explain ahead of time in real English what it is that we're talking about when we get in the middle of these things. Sometimes they can be a little dense. Let me take a moment and introduce the members of the court. On my right is Justice Beth Baker, Justice Jim Shea. On my left is Justice Jim Rice, Justice Lori McKinnon, and I'm Chief Justice Mike McGrath. We have two members of the court today who are unable to be here, Justice Dirk Sandifer and Justice Ingrid Gustafson. They will be participating in the case. They'll be watching the recordings, but they were unable to be here today. With that, this is cause number 21-2260, State of Montana versus Danielle Wood. Are counsel ready to proceed?
Good morning, and may it please the court. My name is Catherine Hutchison, and I represent Danielle Wood. I'd like to reserve 10 minutes for rebuttal. You won't find a case like this anywhere else, where an accountability instruction was allowed to go to the jury, even though the state did not present argument or evidence of two people acting together, using accountability instead as a workaround to the problem of a beyond a reasonable doubt standard in a case full of holes. You won't find the kind of cellular location testimony allowed in this case anywhere else either. While it's true that CSLI data can often be used to give broad estimates of the general location of a phone, the only value to the state of Cy Ray and Mike Fegley's testimony was in the pinpoint precision that they used to claim Danielle's phone and the track phone were right on top of each other and always together. They assured the jury that their methods were absolutely scientifically sound and very precise, concluding the track phone was reliably a tenth of a mile or better, within a tenth of a mile or better of the lines they drew through Thompson Falls, and showed a sleek video generated by tracks representing even more precise locations than that. Trial courts are meant to act as a gatekeeper to ensure that if the jury hears this kind of testimony, it is reliable and accurate. That didn't happen here. The trial court was a sleeping gatekeeper, applying neither Rule 702 or Daubert to what amounts to junk science. To be clear, we are not contesting CLI testimony based on GPS, Wi-Fi, or triangulation. What we're talking about here are Cy Ray and Mike Fegley's conclusions based on very limited Verizon real-time tool round-trip travel data that the track phone was connecting to a single tower in Thompson Falls. But they didn't test this hypothesis about the tenth of a mile, and they didn't have the training to account for its variations. So we don't know how wide that line going across Thompson Falls should have been. Yet, if the arcing line that they had drawn was any wider across a town the size of Thompson Falls, it would have been no use to the state because it would have included so much more of town. Turning to the accountability issue, the state had problems with their case. They accused Danielle alone of shooting and killing Matthew on May 2nd, but their timeline was nearly impossible. Danielle wasn't capable of much of what they alleged. But the near impossibility of the state's charged defense is what we know as reasonable doubt, and it means acquittal. The state must claim a second person is involved to instruct on accountability. At trial, the prosecution didn't argue that it had presented any such evidence. It argued instead that State v. Tower gave it the authority to instruct on accountability without notice, evidence, or argument of two people acting together. But to properly prosecute someone for accountability to another, the state must claim and then present affirmative evidence that Danielle aided and abetted someone else. Here they chose to disavow any such theory, but still wanted the accountability instruction to hedge the jury's doubts that Danielle could have possibly done what the state alleged, acting alone. The state can't have it both ways. There is no precedent anywhere where a jury instruction for accountability was allowed with no evidence of an accomplice, other than that the defendant could not have carried out the offense by acting alone.
So, counsel, what about the verdict form? Doesn't that make up for that?
Well, Your Honor, in this case, the verdict form only reflected deliberate homicide.
Correct.
And the defense requested a special verdict form so that the jury could decide between deliberate homicide as a principle and deliberate homicide by accountability. The district court denied that request and gave just simply the deliberate homicide.
So that's my point. Doesn't that make up for errors regarding the accountability instruction?
Well, Your Honor, the jury was given a jury instruction that they could determine that Danielle was accountable to someone else, and we presume that a jury follows the instructions that they're given. So they were given permission to decide that Danielle was guilty of deliberate homicide by a theory of accountability. And so because they were given that instruction, their conviction for deliberate homicide on the jury verdict form could have, we don't know which one they decided, whether they decided that Danielle shot and killed Matthew LaFriniere or that she helped an anonymous other person. We don't know what the jury decided.
So counsel, what you're implying is that accountability is a separate offense in itself, when it's a theory of liability.
Correct.
And I think that gets at what the chief's question was about.
Right. So, Your Honor, this court has said in State v. Tower that accountability is a conduit for the principal offense, meaning it's a theory of guilt for, in this case, deliberate homicide. State v. Tower, that language came about in State v. Tower through a notice challenge. That case is about whether or not the state is required to give the defendant notice through the charging documents of accountability as a separate offense. State v. Tower said no. This court said in State v. Tower, no, because it's not a separate offense. In the context of notice, it doesn't necessarily need to be added to the information. In that case, State v. Tower is factually different than this case because it clearly involved two actors who I believe were participated in a drug sale together. And the question then was, there were two people participating in a crime. Did one of them commit it, or were they guilty by accountability? In that case, the state had given notice. This court decided that the state had given notice through discovery and through the way that they prosecuted their case. And so it wasn't necessary in terms of due process requirements to give the statutory notification of an accountability charge in the charging document. This court has said that accountability is simply a theory of guilt as opposed to a separate offense in the context of notice. But here, we're talking about the state's burden of proof and the elements that are necessary to prove an offense. And in that sense, accountability is a separate offense to the principal crime, in this case, deliberate homicide. There are separate elements that the state has to prove. So factually, and in an elements sense, they are separate.
Well, that puts you back to the position that it's a separate offense if you've got different elements.
That's correct, Your Honor. I do think it's a separate offense. And the language that we have from State v. Tower, that it's simply a conduit, I believe has been, it's been problematic in the way that it's been used since. State v. Tower was decided in 1994, and there have been several cases that have followed it since. That case really has to do with notice. So the language in that case has been, wasn't quite clear enough to say that accountability is simply a conduit of the principal offense in the context of notice, whether the state needs to put the statutory language of accountability into its charging document so that the defendant knows what they're facing prior to trial. That's what Tower's about, and that's where that conduit language comes from. I do think accountability is a separate offense when we're talking about proof and we're talking about elements.
But again, back to the verdict form, the district judge didn't give a separate offense accountability proposal in terms of the verdict form. The verdict form just talks about deliberate homicide.
Correct, with the understanding that deliberate homicide, deliberate homicide by accountability was, the jury could convict under that. So they should have, the district court in this case should have given a special verdict form with two separate counts. And there was a debate between the parties about whether this should have been charged in the alternative, deliberate homicide for one, in the alternative, accountability by deliberate homicide.
But it wasn't. It was just charged as deliberate homicide.
It was charged with deliberate homicide with two jury instructions, allowing the jury to convict under either theory. The issue that we're raising is that there wasn't enough proof of an accountability theory for the jury to have considered that.
As a basis to convict.
Correct, Your Honor.
And so what you're saying is the problem with the jury instruction, with the verdict form, as I understand it, is because it wasn't segregated between deliberate homicide or deliberate homicide by accountability, we don't know on which basis the jury found the defendant guilty of deliberate homicide.
Thank you, Your Honor. Yes, that is exactly what I mean. We don't know what the jury decided Danielle Wood did because the verdict form reflects only deliberate homicide. So it could have been under a theory of accountability that they convicted. And that ambiguity came about because the prosecution argued for it. The defense wanted a special verdict form so there would be clarity as to what the jury decided. But the court, using the logic of Tower, decided to use a verdict form reflecting only a single offense of deliberate homicide.
So, counsel, we don't see in Montana a lot of conspiracy charges or charged. And I think the accountability statute is close, and we've always said that it's a theory of liability. And what you're proposing is more akin to a separate offense of accountability, which is like a conspiracy charge, except you don't have the element of the agreement. But you're suggesting that we should take something that is a theory of liability and make it a completely different offense from the principal offense.
Well, Your Honor, I do think that they are different, like I say, in the sense of the evidence necessary to prove them and the elements of the offense. So you're right, there is, an option of charging conspiracy, which would require an agreement. But the accountability statutes also provide their own elements. So that requires specific intent as the mental state, and also acts to aid and abet another person. And that's the really critical part in this case, is that there has to be allegation and proof of another actor, a second person. So when we see accountability charge.
Where in the accountability statute does it say there has to be proof of who the other person was?
Your Honor, the accountability statutes don't indicate that the state needs to, give a proper name to the second other person. All three of them do indicate that there has to be a second actor. So if there was a case in which there was an unknown second person, and the state included some examples of these in their briefing from other states, where you don't know the name of the second assailant, but they're the guy in the blue hoodie, that might be sufficient. But you have in that case, you've articulated a theory in which there are at least two actors. And the accountability statute, the 452301 references the conduct of another. So does 452302. But I'd like to also point to, Montana Code annotated 452303, which is the statute that indicates that the second actor need not be prosecuted in order to prosecute someone for accountability for the acts of another. That second person doesn't necessarily need to be charged and prosecuted. It does contemplate, however, that the state needs to claim a second person. That indicates, so that statute says a person who's legally accountable to another may be convicted even though that other person claimed to have committed the offense has not been prosecuted or convicted. So there you have a language of the state must claim a second person committed the crime to which the person currently being prosecuted aided and abetted their actions. And that's where we get the statutory support for the argument. I think there's just a general fairness argument as well, in which, this case was based on circumstantial evidence. And if the state is allowed here, to say, we believe Danielle Wood committed deliberate homicide, but there are parts of our allegation that if you find some of what, only some of it to be true, she can be guilty to another by accountability. The problem with that is what would prevent the state in every case that's based on circumstantial evidence to always charge accountability in that case and say, we will try to prove deliberate homicide, but if we can't, we're going to, use accountability to fill in the holes of our case and say, we have circumstantial evidence that supports our theory, but if you only believe part of it, you can still convict under a theory of accountability without ever alleging that there was a second actor. And that's a problem, I think. That's where we see that in this case, accountability wasn't used in the way it's intended. It was used to fill in holes in the prosecution's case. There were parts of the issue that it just would have been hard to believe that Danielle could have accomplished. And the state said, well, you don't even need to believe what we're alleging to convict under accountability. And the accountability cases we see really have always, there is no other case like that in Montana, and neither party has identified a case anywhere else in the country where that has been allowed. There's always two actors, whether that person is specifically named or they're referred to as the guy in the blue hoodie. Sticking with accountability, for a moment, the cases that, where it's traditionally used and where, really fits much better is what I would call melee cases, where there's something like a barroom brawl, and there are multiple people who participated in an event. And you can't really say who's the one who caused the physical harm if everyone's throwing punches. That's really the traditional use of accountability and where it makes sense. In this case, the state had the opportunity to allege a theory of accountability. There was another person who could have murdered Matthew LaFriniere, and the state specifically disavowed that he had any involvement. And so by choosing that, by deciding not to pursue that theory, and by eliciting evidence through their direct examination throughout trial to indicate their belief that this second person, Drew Stobie, was not involved, they foreclosed their option to instruct on accountability. Not only did they not articulate their own theory, but they specifically disavowed a theory that they may have otherwise been able to articulate about Drew Stobie having helped with accomplishing a murder. And so for the state to disavow the evidence that would have allowed them to pursue that theory and then request the instruction anyway, just shouldn't be allowed.
So I'm trying to understand where you would draw the lines. The state could argue, well, we don't think this other person did it, but we think someone else could have done it. Isn't your position that the state has to pick and choose who they think the other actor is with certainty before they can use the accountability instruction?
Yes, Your Honor, I think that like I say, I don't know that they necessarily need to give a name. They may. It may be a case-by-case situation.
That's what I'm trying to get at. How far does the state have to go before they have established a basis for an accountability instruction?
Well, they would need to articulate a theory that does involve a second person. So we believe that, two people together accomplished this crime. And it would need to certainly would need to take their evidence and argument much further than they did in this case, where they simply argued, they made their primary argument that Danielle Wood committed a murder and shot the gun herself. But they said, if you only believe that she purchased a gun that was later used, then you can convict on accountability. They needed to have articulated that she worked together with someone else. She aided someone else. She was aware of what was happening, and she took affirmative steps to accomplish the result. And rather than articulating one theory, which is that Danielle Wood is guilty of deliberate homicide, but she's guilty by accountability if you only believe some parts of what we're arguing. And that's really the difference, whether they presented affirmative evidence of a second actor or simply an argument that if they just simply accomplished some of it would meet the elements of accountability.
So, that's what a jury gets to do, is it gets to reject some evidence and accept others. It gets to decide what it believes or not. And I guess I'm still getting back to trying to draw the line. Can't the state argue that, if you don't believe all of the evidence, there's still this theory of liability because of this evidence? We have an eyewitness that identifies her at the scene in this narrow window of time when the victim's vehicle is there, and she's purchasing this firearm before, and she's saying that she disposed of it later, and you have all this sort of evidence circling her, couldn't a jury say, well, I don't know that she pulled the trigger, but I think she was involved with it? I mean, isn't there enough evidence for the state to argue that?
Your Honor, I don't think that there was enough evidence to argue that. I think that there was enough evidence for the state to argue that she committed deliberate homicide and for the jury to make a decision on that offense. But in this case, the district court, at the motion to dismiss stage, there was a motion to dismiss the accountability charge, and the district court said, I think there's enough evidence for the state to move forward on that because there's been a suggestion that Drew Stobie had the track phone, that he was capable of, he knew how to fire a gun, he was capable of doing it from some distance, and he was capable of moving a body. So in this case, the prosecution decided, actively and repeatedly disavowed that argument. So then for them to request the jury instruction that required that evidence is where the issue lies. They made a decision in their discretion of how to prosecute their case, not to use that theory and not to argue that evidence. In fact, they argued against it throughout trial and in closing argument. And so that's where the distinction lies in this case.
In your time left, maybe you could address the cell phone issue.
I'd love to. Thank you, Your Honor. So some of the most critical evidence in this case was the expert testimony presented through two witnesses, Cy Ray and Mike Fegley. They were dealing with a body of data, of cell phone data in a unique circumstance because this case arose in a very small town in western Montana, Thompson Falls, where there is only one cellular tower. The track phone is the phone that its whereabouts on May 2nd was the critical issue in this case. We don't contest the testimony about Danielle's phone and where it was in a general sense because the data underlying the testimony about her offense included GPS, which is undisputedly the most accurate. It included Wi-Fi data and this RTT data. So we're not contesting Wi-Fi or GPS. And if triangulation were possible in this case, we wouldn't be contesting that either. In this case, there was only one cellular tower, so triangulation was not possible. We're talking about the experts' reliance on 22 data points, which are called round-trip travel. Real-time tool is what RTT really stands for, but round-trip time, the time it takes for a cell phone to connect with a cellular tower and come back to the cell phone. We know that those measurements are not very accurate, and their accuracy depends on things like the geography, topography of an area, the distance from tower, the line of sight from that tower. These kinds of things affect the reliability and the accuracy of this RTT data. In this case, the expert witnesses gave testimony that Danielle's phone and the track phone were hand in hand with each other, and they gave exceedingly precise predictions of exactly where the track phone was on very little data. They didn't have the expertise to make these kinds of assurances to the jury, which, taking a step back, expert testimony it's so important for a district court to examine it prior to a jury hearing it because of the weight it carries. If a jury is to be assured that this is scientific, this is objective, this is reliable, any juror is going to give that a lot of weight. But if the witness's qualifications and the data that they're using and the methodology that they're using to come to those conclusions is unreliable, then that causes great prejudice to a defendant. In this case, in cases across the country, cell phone evidence is used often to give very general locations of where a cell phone could be. If you survey state and federal court cases that apply the rule of evidence 702 and Dober, but either one, this evidence in Danielle's case about the track phone should not have been admitted under either standard, 702 or Dober. You won't find a case that is where a court who has meaningfully examined the proposed testimony that an expert's going to give that allows the kind of specificity that the court allowed in this case. And that's because the data isn't accurate. It can be accurate to show a general location, but it can't be, it's not, there's almost a universal agreement that it's not accurate to show the kind of precise conclusions that the experts in this case drew. They said that it was mathematically impossible that these two phones weren't extremely close together. They told the jury that their methods were absolutely scientifically sound, that it was very precise, that these phones were right on top of each other.
So, Ms. Hutchison, is it your position that these witnesses could have testified as experts in the case had their testimony been more generalized?
Your Honor, I think that there's some limited extent that their testimony could have been relevant to the jury's determination of the location of these cell phones. It was limited, though, because both of these witnesses did not have training they weren't engineers. They didn't have any specialty in radio frequency. They were both former law enforcement, and they work with a tool called Tracks that maps data. I mean, they use it as an investigative tool. Both of them testified that their experience was, using cellular location data to find lost hikers in search and rescue contexts, and as a game warden to see whether or not someone who's claiming to have a in-state residency for hunting permits, whether they really do spend the majority of their time in Montana or it's elsewhere. So their experiences in looking at the data and in a general sense, looking at what it means. They didn't have, and they admitted that they didn't have the expertise to do things that could have verified the accuracy of the data they were using in this case. So they didn't do a drive test, and they didn't have the expertise to verify whether the data they were using was accurate in terms of, traditionally a radio frequency scientist would look at the tower, look at the antenna, inspect the condition of it and the position of the three antennas that come from a cell tower. In this case, the witnesses said that they could corroborate the data by looking at the state's other evidence in the case and decide whether the cell phone data was accurate based on whether it matched the other evidence in this case. And that's maybe a law enforcement tool for investigation, but it's not science. And so to be presenting to the jury scientific conclusions, that was the problem. They may have been able to answer your question, Justice Baker. They may have been able to give limited testimony about what their training and experience says using data in other places. But for them to tell the jury that these RTT measurements were accurate and reliable up to 1/10 of a mile in variation, that was the only evidence that would have caused the jury to believe that Danielle Wood would have been the person with the cell phone, rather than if they had been allowed to testify but give much more general conclusions, would have been no use to the state, really, but it would have been more acceptable in terms of, that phone could have been with any number of people in a town the size of Thompson Falls. So it's
Count-
really the precision that it was problematic.
You can answer this in your rebuttal or whatever, but I guess my first question is, I mean, I think in a Daubert 702 hearing, the district judge has the function of a gatekeeper. So I don't know how, I guess you're saying that the gatekeeper function depends on the particular facts of the case?
Correct, Your Honor. That's the critical role that a district court needs to play in, when the defense or, when the,
Even if the scientific evidence is not considered reliable? It's reliable on some facts? Do you see what I'm asking?
Yes.
And you don't have to answer it now, because,
I'll answer it quickly, and I may elaborate in my rebuttal. So the admissibility of CSLI, cell phone location testimony, is highly fact-specific. So it does depend on the witness's qualifications, the methodology that they're using, and the data that underlies, that they have to use. It is the trial court's obligation to examine all three of those things if it's challenged. In this case, it was, because it's the proponent of the evidence who's required to prove that their expert testimony is accurate and reliable. So if it's challenged, then the district court would need to examine those three factors and make a case-specific determination about whether the proposed testimony is admissible. We can't say that all cell phone location testimony is reliable and all of it's not. It's really a fact-specific question. In this case, it's clearly on the side of unreliable in relation to the round-trip travel time that was used to give precise locations of the track phone.
So
And with-
let me just clarify. As I understand it, your challenge is not specifically to the use of the RTT methodology. Your problem is with the qualifications of the experts to testify and their approach as to what they did to use that information. Is that correct?
That's not quite correct. We are challenging the experts' qualifications, but also the use of the RTT data, in this case, to make highly precise predictions of where the track phone was. But we're not-
Only to the extent of the precision, which is what the experts used, not per se use of RTT evidence.
Correct, Your Honor. There are a few cases that have been cited in the briefing that includes the use of RTT data. Those cases differ, however, from ours because RTT, when it's used in conjunction with GPS, Wi-Fi, and triangulation, is one thing. When it's used all on its own in very limited quantities, that's a complete other question. So there are cases cited in the briefing where RTT was used in a bigger metropolitan area. Grand Rapids, Michigan is one example in US v. Reynolds. There's GPS, Wi-Fi, and RTT data associated with the experts' conclusions in that case. The court took a little time to explain why they accepted the RTT data in that case as well, both because it was used together with Wi-Fi and GPS, known to be more accurate, and because the RTT measurements were from multiple cell towers. So they had measurements from one tower that said, this phone is connecting 3.5 miles from this tower and 1.5 from this tower. In that case, you can map two arcs, and you can
We
see where they
understand
intersect. And that is triangulation. That's what wasn't possible here, because Thompson Falls has one cell tower. And that's the specific testimony that we're challenging. I'll save my final 2 minutes for rebuttal. Thank you.
please the court, counsel. My name is Bjorn Boyer. I represent the state of Montana in this appeal. This court should affirm Danielle Wood's conviction for deliberate homicide because Wood has failed to show on appeal that the district court abused its discretion when the court instructed the jury on the theory of accountability. And because she has failed to show the district court abused its discretion in admitting the CSLI evidence. Regarding the accountability instruction, the state proved at trial beyond a reasonable doubt that Ms. Wood traveled to Matthew LaFriniere's residence and shot him that night. However, even if you accept as true her argument that there was somebody else involved, that there was possibly another triggerman, there is still no doubt that she engaged in discrete acts that night to make her liable for the murder as a participant in the murder. Nevertheless, Wood argues that the state was not entitled to an accountability instruction because the state's principal legal theory was that Wood pulled the trigger and the state did not identify an accomplice or exactly how an accomplice was involved. Those arguments simply are not relevant to whether there was a sufficient evidence adduced at trial to get the accountability instruction. A district court may instruct the jury on theories and issues that are supported by the evidence. And here, Ms. Wood herself introduced evidence that there was somebody else possibly involved. She was the one that introduced evidence that she could not have moved the body, if it was even moved at all, the 17 feet from the first puddle of blood to his final resting spot where he was hidden underneath the plywood. So Ms. Wood introduced evidence herself that would allow the state to request that instruction.
Can you address the verdict form issue and the argument that we can't tell whether the jury or some members of the jury might have used the accountability theory and some members of the jury might have used the direct deliberate homicide theory, and whether that makes a difference?
So here, no, it does not make a difference because it's just a legal theory. The accountability instruction is a legal theory that allows the jury to convict. So the court was not required to have a special verdict form. That was the way it should have been. But furthermore, in this case, even though it wasn't required, there was a unanimity instruction. So the court specifically told the jury, you have to all agree on an act or set of acts that would make Ms. Wood guilty of the homicide. And so even though that instruction wasn't required, it actually increased the state's burden of proof. That, I think, solves that potential problem, Your Honor, because we know the jury did agree either that she pulled the trigger or that she was liable because she participated in another way because of the unanimity instruction.
And as I understand her argument is that the accountability, where it's a matter of the state's proof, is a separate offense because it requires a separate element.
Yeah, addressing that, I think that's not correct. That would require, if the court finds that, it would require the court to overrule decades of case law finding the exact opposite on that point. I mean, this court has repeatedly held that it's not a separate offense. It's just a conduit or a theory of liability. And that wasn't even argued in the briefs. I think that's a novel argument today.
But I think their point is that, well, you can't have it both ways. I mean, you can either allege accountability as an alternate charge and support it with evidence that the defendant was accountable for someone else's action, but you can't say there's nobody else involved, but if you can't convict of deliberate, you can use this accountability. I mean, the state has to prove something about another actor.
No, the state doesn't have to prove something specifically that the other actor did.
To get an instruction, to get an accountability instruction, you need sufficient evidence.
The state has to prove, one, that a crime was committed, and that the person, the defendant, was liable somehow for that crime, right?
So if somebody wants someone dead and that person winds up dead, is that sufficient to say, well, we don't have any evidence that they did it, but they wanted him dead, so they're accountable for whoever did do it?
No, because the state would have to prove discrete acts that would make that person liable, right? If that person said, well, I want that person dead, and there's also evidence that that person, purchased a murder weapon, and maybe there was text messages, asking somebody else to do it, but we can't identify who that other person is, then you would have actually discrete evidence. It doesn't make the...
Another person.
What's that?
There does have to be another person.
Correct. There would have to
So
be another
who
person.
was the state claiming was the other person in this case?
The state didn't claim that anyone else was involved, right? That was evidence that Ms. Wood put on. Ms. Wood put on that someone else was involved,
Well,
and
the state goes first and has the burden of proof. So
Correct.
at the close of the state's case in chief, who had the state been claiming was the other person?
see, the state doesn't have to identify the other person. The
No,
state,
and I get you don't have to say what their name is and their social security number, but I mean, are there footprints? Is there somebody, I mean, and in this case, I mean, the state was disclaiming. I mean, there was an
Correct.
affirmative disclaiming of another person's involvement. And that's the thing that that I think is distinct between saying the person in the blue hoodie or the person who, you know, they transferred money to an offshore account and somebody else took it out. I mean, those are all things that I think, but I mean, I mean, the statutes specifically contemplate that there is another person. And I mean, in Ms. Hutchison referred to 45-2303, it specifically referenced the other person claimed to have committed the offense. And I'm struggling with who the state, who bears the burden of proof here, even under the theory of culpability here, who it was claiming was the other person. I mean, just even in the abstract.
the state didn't make a claim of who that other person might be. I mean, if you want to like talk about hypotheticals, right? I mean, what possibility could have
How about
happened?
just addressing why did they ask for the instruction?
So the instruction was, Ms. Wood specifically argued that if you can't prove that she pulled the trigger, you have to acquit. Right? And she repeats that on appeal. And that's not a correct statement of the law, right? We get that from State v. Duncan. I mean, State v. Duncan says either the state can prove that the person pulled the trigger or provided the murder weapon to someone who did, right? And in this case, the state proved discrete acts making her liable for the offense. One, the state proved that she purchased the murder weapon, and if she didn't pull the trigger, that she supplied that .38 caliber handgun to whoever did, and also that she pulled, or that she made the diversionary 911 call, right? That she intentionally diverted law enforcement away from the scene. So even if she picked up a hitchhiker en route to Matthew's house that night, gave him the gun and pulled the trigger, and the state never learns of that hitchhiker's identity or how that hitchhiker was involved, the state proved discrete acts that would make her liable as a participant in that murder. So the state can use an instruction as a backdrop from preventing the defense from making an incorrect legal argument. Because she wanted to argue to the jury that if you can't prove I pulled the trigger, you have to acquit. And that simply was not a correct statement of the law. And so the state was entitled to provide that instruction to argue, even if Ms. Wood is 100% correct, and even if the state can't prove she pulled the trigger, she's still liable because she did these specific things. And the state argued in the closing argument that she had purchased the murder weapon, that was the gun that was used for the homicide, and that she had made that diversionary 911 call. So there was sufficient evidence to go to the jury on that issue. The Montana Code annotated.
So counsel, I
Oh,
just
yeah.
want to make sure, so in any case in which a defendant says they didn't do it, does that open the door for an accountability instruction?
No, there would have to be concrete, admissible evidence to prove that they would be liable. So a conviction for accountability is not contingent on exactly what the accomplice did. The state doesn't have to prove what exactly the accomplice did. The state has to prove beyond a reasonable doubt a theory of liability for the defendant on trial. And they did that in this case.
So if you accept, counsel, that, if you accept that there was insufficient evidence for that instruction, what's the effect of that?
In the cumulative error section of our briefs, I argued that even if this was an error, even if the court should not have given this instruction, that Ms. Wood was not prejudiced by that instruction because of the overwhelming amount of evidence for the deliberate homicide as her pulling the trigger. And so I would repeat that I don't believe that it's reversible simply because you conclude that the district court erred in giving that instruction. Importantly, one more point on this before I move on, is that nowhere in the statute, nowhere in the accountability statute does it say the state has to prove the identity of an accomplice or prove who that person is or what exactly that person did. The accountability instructions only require the state to prove how the defendant was liable or participated in the murder. And Ms. Wood, on appeal and in her reply brief, states that the state has not cited any case that is remotely similar to this. And that's not true either. The state, in its response brief, cited U.S. v. Clark, which was an Eighth Circuit Court of Appeals decision. It's not exactly similar facts. There was a marijuana grow operation where basically the state said this guy lives at the residence part-time. He's the one that's growing this marijuana. And his argument is, well, I don't live there the whole time, so somebody else could be involved in this. And the court, the Eighth Circuit Court of Appeals said, no, I mean, the state can use that as, they called it a fallback theory. And even if everything the defendant says is true, then the state can proceed, or the government could proceed on the accountability theory. So that's the U.S. v. Clark. And tellingly, that's the only case that Ms. Wood does not distinguish in her reply brief. Moving on to the CSLI evidence. I believe Ms. Wood's counsel described pretty well what the RTT data is in this case. And she's correct, that's the predominant data that was used, other than the Google location history data, which Ms. Wood today admits is precise and can be relied on. All of her case law that she cited is dealing with a different type of evidence. It's dealing with call detail records. And so call detail records exist whenever a call is made. And they're often called CDRs. But CDRs usually contain the time of the call, the length of the call, and the tower and sector that was used for the call. So you don't get a whole lot of information. You just get the tower that was used and the sector of that tower. And so then what you have to figure out, or what the experts have to figure out, is what is the coverage area for that tower, and then typically is the crime scene in that coverage area. Importantly, RTT data often is not available. The cell phone companies don't keep it for as long a time. So a lot of the cases out there don't specifically address RTT data. The CDR data is available for much longer, and so a lot of the case law that's out there specifically addresses the CDR data. So this data is more frequently available and is analyzed much more in the case law. But it doesn't tell you as much. It just tells you basically a general location of the phone at the time of the call. And in this case, it's not incredibly helpful because there was only one tower in Thompson Falls. So the coverage area of that tower was extremely large. I think Mr. Fagley and Mr. Ray cited that it could be up to 648 square miles. So that data didn't tell us a whole lot. And importantly, the drive test that keeps getting mentioned is something that only verifies the call coverage area. So basically what they do is they get somebody with a scanner, they go out to that area, and they send these pings back and forth between the tower, and it basically verifies, yes, this call could be made from this tower. This location where this scanner is within this coverage area of the tower. So a drive test would not have done anything in this case. To my knowledge, there's no drive test that will verify RTT data.
Oh, didn't the witness acknowledge that they had used drive tests before to verify their data?
Yeah, Mr. Ray and Mr. Fagley both talked about drive tests, and that it is a way to verify the CDR data, the call coverage area data. But Mr. Fagley specifically testified that no, it's not used to verify RTT data. That's not something we do to verify RTT data.
And isn't the evidence that RTT data is commonly used in the industry?
It is. That's correct.
It's not some mystery science.
No, and it's been around for just as long as any of this other data. There's not as much case law on it simply because it's not as often available in cases. But I mean, the state cited in its brief several cases that did discuss and addressed RTT data. And in fact, there's cases coming out all the time. The Nebraska Supreme Court just a couple of weeks ago ruled on the admissibility of RTT data.
So I think I think the biggest issue here is the nature of how it was used and the precision that the witnesses testified to, and especially that video. I mean, it's a pretty slick video, and it's quite compelling. And I think the question here is, when they say it's a mathematical impossibility that those phones weren't roughly in the same area, just because they said roughly in the same area, or words to that effect, that testimony is very compelling. And what supported that kind of conclusion here?
So there's a couple of questions, Justice Baker, within that question. So neither Ray nor Fagley overpromised on the data. Importantly, first of all, they were very careful to say, we cannot use this data to put a person at a specific time in a specific place. They also testified, we can't tell who had this phone, or even if it was just one person that had this phone. Fagley on cross-examination conceded that, yes, Ms. Wood could have had her phone and Mr. Stobie could have had the track phone, and they could have just been together every time the track phone was producing RTT data. So that was a possibility. So neither of the experts used the data to say, we can tell that Ms. Wood was in this specific place at this specific time. In fact, it was actually Ms. Wood that made that argument. And when she incorrectly argued that the RTT data from her phone could not have put her at Matthew's residence before 7:38 and 46 seconds. So she argued the RTT data was so precise that that was the earliest that she could have gotten to that residence.
I thought that was the Wi-Fi data that they got that.
And so that was incorrect from Ms. Wood's brief. That was not Wi-Fi data, that was RTT data. In counsel's opening brief, it did say Wi-Fi data, but that was incorrect. And so they were using that RTT data, which apparently they did think it was reliable, right? Because they're arguing it to say it was very specific to put her at a specific place at a specific time. And they did it incorrectly because the data actually showed her, it was consistent with her arriving a couple minutes before that. So what Ray...
A question just on the district court's order in this regard. I mean, the district court only did a paragraph in terms of the admissibility of this under Delbert. And what it cited to was four cases from other jurisdictions. And if you know, were these cases, did they involve just RTT data alone, or were these cases ones that involved RTT data at all, or in conjunction with the other methods like triangulation?
No, I don't believe any of the cases cited by I don't know that all of the cases cited by the district court even involve cell phone evidence, to be honest. But no, I don't know that the court specifically addressed the RTT data within those cases. I don't believe so.
Thank you.
Going back to Justice Baker's question, if I may. So what Ray and Fagley did testify to is that it would be mathematically impossible for these phones to not be together. Right? They testified that the evidence was that they were perfectly paired, but that didn't overpromise on the data. That testimony only describes the obvious. If you think about it, there are an infinite number of places that both of those phones could be if they're not connected to each other. They have no correlation to the one to the other. So you only need one data point. Assume those two phones actually belong to different people. And just by coincidence, when they first become active in Missoula, they're separate people, but they're at both the same distance from the tower with those phones. You would only need one of those people to go slightly in another direction at any time for the data to no longer match up. And that simply didn't happen here. So you have 22 different data points over separate locations on separate days. I think that mathematically impossible is about the only way that you could describe that. Because it happened first in Missoula, and then the data was consistent with those phones traveling together to Thompson Falls, and then the data is consistent with those phones being together over multiple locations in Thompson Falls, at her residence, then at another residence on the west side of Thompson Falls, and then finally on Gulf Street where she makes the 911 call. So, and in fact, Wood has never provided another plausible explanation for that data. And that's what she could have called an expert to testify about. The evidence, first of all, it was not novel, so Daubert doesn't apply. It's only a Rule 702 analysis. And this court has repeatedly held that 702 is to liberally allow the admission of expert testimony as long as the expert is qualified. And here, both of the experts were indisputably qualified. Cy Ray, for example, he has 25 years experience in doing this exact thing. He worked for the Gilbert Police Department, finding phones, then he started ZX. The Department of Defense trusted him enough to send him to Afghanistan to track cell phones. I don't think there's any doubt that Cy Ray was a qualified expert, and the same with Mike Fagley. And in fact, with Mr. Fagley, multiple appellate courts have found him to be a qualified expert witness. And so she could have called, and so the evidence was admissible. It passed 702, one, because it required expert testimony, or at least it was allowable to have expert testimony on this subject matter. And then they were both qualified witnesses to testify on the expert testimony. The reliability of the evidence then mostly goes towards the jury. The fact finder can decide whether that qualified expert correctly testified about that admissible testimony. It wasn't for the district court. Once it did its gatekeeping function, it wasn't for the district court to keep that out. It was for Ms. Wood to present cross-examination and refute that testimony through calling her own experts.
I guess I'm sorry to belabor this, but it just shows my ignorance on how all this stuff works. When you say the 22 data points all showed them in the same area, the way I understood how they measure the data points to show where they were was just basically by plugging an algorithm into Google Earth. And how accurate is that to actually measure distance, or isn't there a wide variability on where each one could be? That's what I'm having a hard time with.
Sure. So the track software, as far as the RTT data points go, it's just mapping a distance, right? Verizon provides the distance. So Verizon will tell you, and this was all the underlying raw data was admitted at trial. But Verizon will tell you at this time, this phone was approximately 3.7 or 3.71 miles from the tower, right? And then that goes on to an arc. And that's what they plot. So the size of the line in Fagley's presentation, I mean, you have to pick a scale at some point, but the underlying data saying this is 3.7 miles from the tower, that was admitted.
Was there foundation from Verizon for that?
There was foundation from that from Mr. Ray and Mr. Fagley. No one from Verizon, no engineer from Verizon testified, and you don't need an engineer to testify to that. In fact, no court has held that you need a radio frequency engineer to admit this type of evidence.
But doesn't Verizon, specifically as it pertains to the RTT, I mean, they have a disclaimer as to its accuracy. I mean, they state specifically that measurements with a in reference to RTT, measurements with a high confidence factor may be more accurate than measurements with a low confidence factor. And that they say that the latitude and longitudinal on the RTT are derived solely from round trip. They are best estimates and are not related to any GPS measurements. I mean,
So that disclaimer is one from Verizon, but that specifically relates to data that was not admitted in this case. So Verizon also provides, with the RTT data, they will provide a latitude and longitude. And Fagley and Ray both testified because of that disclaimer and because of what we've heard from Verizon, we don't map that latitude and longitude, right? The latitude and longitude, that's putting it on a dot, right? With the RTT data and what was admitted at trial was just putting it somewhere on this arc at a certain distance from the tower.
120-degree arc.
Right. And so that disclaimer really doesn't apply because that data wasn't used in this case.
Counsel, can you address the Dolbear factors in 702 and specifically the peer review? What peer review has there been of the RTT other than that it's used by law enforcement?
So first of all, just going back, so the Daubert factors don't apply, right? But if they did, Daubert looks at reliability, right? I mean, so it's not a check the box. You have to prove each one of these factors up. Multiple courts, and if you look at this US v. Reynolds case that I cited in that supplemental that I provided the court, specifically looked at peer review and said, look, these things are primarily used by law enforcement. There might not be any academic research on this issue simply because it doesn't interest any scientists to do the academic research. And so the fact that it has not been peer reviewed, that's not fatal to the case.
I think there is a lot of interest in whether this data is reliable and whether
Right.
convictions are being had on unreliable data. There's law review articles listed. I mean, I think there is interest. And there's
There
also
is.
there's peer review, I believe, that has not said that it's reliable.
I'm not aware of any peer-reviewed articles that would say the RTT data is not reliable. If you look at the defendant's brief on page 70, she cites to a scientific article by Dr. Vladan Jovanovic. I'm sure I'm butchering his name, but it's on page 70 of the response, or of the opening brief. And Dr. Jovanovic, who has radio frequency engineering expertise, really takes issue with how Cy-Ray maps the call coverage area. But if you look at that article, he actually says RTT data is reliable, and he gives some figures on that. If you read the article, he said that the RTT data is generally reliable within 89 meters of that distance for Verizon in all but 33% of cases. So in 2/3 of the cases, it's going to be reliable to within 89 meters. And in all but 5% of the cases, it's going to be reliable if the conditions are right to within 150 meters, which is exactly what Cy-Ray and Mike Fagley testified to. They testified that, yeah, generally, we're going to see that this data is reliable to within about 1/10 of a mile. And importantly, in this case, we know that's correct. We know that that 1/10 of a mile error rate was correct, because you have Google location history, which Ms. Wood today has admitted is reliable, right? So we know, we basically have a control within this case. We know where her phone is at specific times because her Google location history is saying it's there. And that RTT data for the same time periods are always within, I think it's 5/100ths of a mile, or 5/100ths of a mile of that Google location history. And importantly, the RTT data is being kept by Verizon, right, through towers. The Google location history is by Google, so a completely separate company, through Wi-Fi routers. So they're not dependent on each other at all, but they're for the same phone, and that phone can only be in one place at a time. So we know that the RTT data is accurate because there's the control of the Google location history that's always telling us that the RTT data is accurate.
We don't have the Google location history on the track phone, though, do we?
That's correct. But there's no reason to believe that if the RTT data is accurate for Danielle Wood's phone, that it wouldn't be accurate for the track phone in the same general location. Really briefly, I want to just address the harmless error argument before I run out of time. In this case, the track phone, basically the RTT data was used for two purposes. One, to show that Ms. Wood went to Matthew's residence in a time frame that was consistent with the murder, and that's been conceded, right? Not only did Lydia LaFriniere see her there, but that's also been conceded on appeal. The state also used it to show that she made the 707 text message, the decoy text message purporting to be from Matthew, that he was held up in Trout Creek, and then made the diversionary 911 call at about 7:26 p.m. But even if you take the CSLI evidence out, the state still proved by other facts that Danielle Wood had the track phone and that she was the one that used the track phone. First, Wood called track phone customer service within minutes of that track phone becoming active, which is circumstantial evidence that it was her that purchased that track phone. The 707 Trout Creek text message implied a knowledge that only Wood or someone very close to Wood would have, right? Because it was purported to be from Matthew about picking SL up from Wood.
I'm sorry, but you just said something that reminded me. Was there a reason why, and I just wasn't clear from the record that, so when it was first turned on, it was in Missoula, that's where the track phone was purchased.
Correct.
I mean, I know that there was the problem in Thompson Falls with there only being one cell tower. Is there a reason why there wasn't an ability to triangulate these two phones in Missoula?
They did, I mean, it bounced off of, I think, a couple of different towers, or maybe it was just one tower to the north of that location. I don't know that she connected to any other towers. And then as you see, like, as you go from north of Thompson, or towards Thompson Falls, the Google location history was pinging on that route. And the triangulation issue is really a red herring in this case. Like, it's really not that important. I mean, typically, you're gonna use triangulation to prove up where one tower is gonna hand off to another tower. And that's just not that issue in this case. With that, I think I'm out of time. So I'd urge you to affirm Ms. Wood's conviction for deliberate homicide. Thank you.
Ms. Hutchison? We tend to ask questions, so you got 2 minutes and 24 seconds.
Thank you, Your Honor. With just a couple minutes left, I just wanted to make a couple responses to counsel's arguments. First, I just wanted to get to the question of what other explanation could there be that the data was similar between, the RTT data was similar between Danielle's phone and this track phone. And I want to address that with an example that Mike Fegley gave in the motion in limine hearing prior to trial. There was an instance on May 8th where Danielle's phone was located at her boyfriend Drew Stobie's house. The RTT data at the time that her Wi-Fi was connecting to a known location was way off in the woods. And Mike Fegley's explanation was that, well, it must have bounced off a ravine and up the ravine, and that's why it was so inaccurate. That's why testing this data is so important, because we don't convict people based on, there's a 2/3 chance that this data was reliable. That's the kind of thing that a jury shouldn't know about if it doesn't have enough reliability. So that was an example that Mike Fegley gave of an example of how this RTT data can be thrown off and why it's so important that there be an adequate factual basis for the kinds of assertions that they're making. I also just wanted to address the accountability issue, question that Your Honor asked. Why did the state ask for an accountability jury instruction if they believe Danielle pulled the trigger? In the lower court, the prosecution argued that they were simply entitled to that instruction without evidence of an accomplice because of State v. Tower. And that's really just a misreading of Tower.
And I know you've only got a few seconds, but as the state argued, I mean, Ms. Woods made the claim that there was another, and specifically identified somebody. Does that, and I get that they said it wasn't, but I mean, does that not open the door?
May I answer the question?
Yeah,
Your Honor, in another case, it might. In this case, it didn't because the prosecution specifically disavowed that, that the other person alleged by the defense, which the defense has no obligation to prove anything, was involved. So when the state specifically disavows the evidence they would need to rely upon for that instruction, they have not earned an accountability instruction. I would ask this court to reverse and remand Ms. Wood's conviction so that Danielle can have a new trial, one that this court can feel confident was fair. Thank you.
That concludes the oral argument in this matter. Thank you to both counsel. Excellent arguments. We will take this matter under advisement, and we will issue an opinion in due course. Thank you all for coming.